she'll flip her lid. They will cuss at you. People do that to me a lot anyways, but in that particular occasion, they get almost violent about it. Those two words scare the hell out of any banker, unless they're the ones writing it. Without recourse means that $50 check that your buddy gave you, if it bounces, the bank eats it. They can't go after you for it. The bank eats it. If they can't get it from your buddy, they eat it. They can never come after you for it. Without recourse on everything. How many of you have a driver's license? See, you're all wrong again. You got to stop this wrong thing. You don't have a driver's license. You carry a driver's license. You are a holder of a state-issued license. You cannot have a driver's license. It's not physically possible under the law. So, I, once again bored, went down and got a new driver's license that I was going to hold for the state. And just to see how many people I could upset, I wrote without recourse under my signature on my driver's license. Remember that day? I had to call Cindy and have her call one of my attorneys because I just lit up the city of Scottsdale. I mean, they're a DMV. I had to go through 3 layers of management, and I didn't know they spoke like that in public. But the whole thing was packed, and they are using the F word, everything. That they don't even know my ancestors, and they were talking about them. They were not going to give me this license. Those 2 words are very important. I put them on everything without recourse. I sign my name, chances are without recourse going on something. You're not going to believe how powerful this is till you do it. So just get a check, go down, endorse the back, write without recourse on it. Drunk guy was right. So why is this so important? It's so important because the UCC used that. Yeah, Patrick's coming.
Okay, going back on without recourse on a promissory note. I had the opportunity, I'm working with a lawyer on that recourse, and I have asked my lender to show me my promissory note. And on February, they showed me a promissory note which was endorsed right underneath my signature, paid to the order without recourse by Washington Mutual, signed by the Vice President. So what does that mean?
Okay, I'm going into that. Where do you see the term pay to the order of? Check or money order. That's it. So when they stamp pay to the order of without recourse and endorse it, what did they just turn the promissory note into? What do you do with the check? Okay. So then did they sell your check? Your promissory note that they converted to a check, they sold it, correct? What can you sell that you don't own? Nothing if you're not the government. Nothing if you're not the government. So if they stamped it and then they sold it, what did they prima facie just prove? They bought it, they owned it because they bought it, and they bought it with the house. We're done. It's done. That's why the UCC says if you alter this promissory note, you cancel the, actually it uses the word discharge. Discharge is another legal term. You discharge the obligation of the obligor. Now, why did they do that? Because they wanted to sell it to their friend's bank, get that $1 million, put it in their account so they could lend out $27 million. Then what does their friend's bank do? They sell it to the other friend's bank so that they get the $1 million so they can put it in a deposit account and they lend out $27 million. I've seen these things with 32 stamps on it. And I think it was like a $282,000 promissory note. Do the math. This piece of paper generated the bank hundreds of millions of dollars in loans backed by nothing. That's like giving an 18-year-old a credit card, guys. You're going to have an issue. And that's what we've done in this country, and that's what we're paying for now. So that's why. If you understand that, now does that make sense to everybody? Now you see why the scam works the way the scam works. I don't know what else you'd call it other than a scam, but it's a brilliant scam. It's worked very well. It's destroyed the middle class. It's destroyed the country. And it's made the politicians mega wealthy. Just ain't done much for us. That's the whole thing, guys. It really is. Yes, Patrick. Excuse me, Patrick. Patrick. Yeah, we've got a question, buddy. Thank you. The other one?
Okay, I brought all my papers with me from New York when I came here. I have a copy. They made the mistake of sending me a copy of this promissory note. I have 4 stamps on it, paid to the order without recourse. Now, you did mention earlier that the authenticity of the signatures, especially in terms of this without recourse, because I think that gets them off the hook. But
No, the authenticity of the signatures is about every aspect of the document. And will be, it's not just that. There's all kinds of false signatures.
Okay, because I got this little copy of it. They got 4 of them on here. So once I got this back, I only got it once. They didn't answer all my inquiries, but somebody in the bank slipped. And they sent this to me. And I wondered about it, but without the recourse now, the people who currently trying to foreclose on my home now, their stamp's not on this because I don't know how old this thing is. It's not on file anywhere. Okay.
No. Right. Okay. Is the deed of trust on file somewhere?
Yes.
But the note's not on file?
No.
Are they the same document?
No.
Okay. Then we're done. No. I don't tell you record anything at any time. I'm spending so much of my time keeping people out of prison because they went down and recorded something.
All right. I think I understand why they don't record it, because they change the nature of it. So if they do,
there's no reason to record a promissory note.
Okay, so they did not record this now. But this paid to the order of without recourse by all of these people, I had no idea about any of these people.
Okay, stop. It's none of your business. Okay. It's none of your business. If I sell you my car and you go driving down the road, if you decide to paint it green, are you going to have a problem with me coming and bitching at you saying, I want to see my car? Why the hell did you paint it green?
No.
Yes, you will.
Oh, wait,
You're not going to want it. Well, no, please, you've got to let me finish or you won't understand this. When you sold the bank your promissory note, you're done. You're done. If you sell somebody something, you forsake the rights to that object. You can't complain about it. You don't get to ask to see it. You're done. Okay. The caveat. It's very important you understand the caveat. Why do we, in the documents, in the cases that I deal with, why do we talk so much about the note? Because there's a caveat. If I sell you my car and you're driving down Scottsdale, a little too long in handlebar J's, danced a little too much, and the jack was cold, and the women were hot, and you're in the lake, nobody finds the car. You may come back to me and say, hey, John, you know, I gave you the money for the car. You need to give me the car. I better be able to prove you left with my car, right? So I go, listen, I pull the tapes from the DMV to show that you were there and that you registered the car. I show that you bought insurance on it. I show that your picture and a red flex, red light camera where you got a ticket. I got to be able to prove you actually picked up that car. That's the only reason we discuss the note. Do you understand that? But other than that, If you bought my car, I can't tell you I want to see it. If that bank bought your note, you got no business telling them to show you the note. Do you understand that?
Okay. All right, so we have no interest in the note. We relinquish all our interest in the note. That's what you're saying.
Right. And one of the things that I try and teach people, and it's a very hard concept to understand, is anything that they do can be in their favor or it can be against them. That's called the onus probandi. And if you want to win in court, you've got to be an expert at reversing the onus probandi. In other words, we had a case. Bill was actually the expert witness in the case. Did a great job, hammered the banks. Then the plaintiff went into court and blew the thing. At least that's what everybody else thought. Because she got on the stand, and the attorney said, did you get a loan? She said, yeah, they gave me the money, I got the loan, and blah, blah, blah. Well, by her admitting that she got the loan, you'd think the case was over with. But let's talk about reversing the onus probandi. It hit me a couple days later. It's like, wait a second. Doesn't matter what she thinks. She never got the loan. So by her believing she got a loan, didn't we just prove something? Didn't we just prove that the bank's fraud was effective? You see what I'm saying? Reverse the onus probandi on them. The note has nothing to do with what we're talking about. You've all been brainwashed to believe it does. All men like Bill that knows everything about banking, or the other forensic examiners, these people can track down the notes, track down the deals. And that's very important because you got to prove certain aspects of the deal was consummated. You got to prove the fraud. But in essence, they bought your note. What did they use to buy your note? The house. So therefore, it's your house and it's their note. What if the bank says, hey, I want to come in and tell you what color to paint your living room? What are you going to tell them? Yeah, I know what I'd tell them. Don't talk that way. So the same thing, and that's how the banks look at it. We bought your note. They just don't want to say it because then it's over with for them. Let me see what time it is. I'm sorry, I thought I did say that. Yes, if they kept the note, if they kept it with the deed of trust, like the law tells them to do, it'd be over with for you guys. That's what's happening. That's the way the law presumes everything to have happened because you didn't argue it effectively. The law operates under the presumption that's the way it happened. You need to inform the court that is not what happened. Now, when you do that, when you look at that prefatory statement on the latest complaint, Bill was able to discover where Cindy's note actually was, and none of the banks trying to foreclose on her actually had the note. So, I mean, off the top of my head, that's 13 felonies, and I can move that right into terrorism under the USA Patriot Act. That's a problem. As long as we rebut the presumption that they didn't do it lawfully. Do you understand that? So, when we discuss the note, we must do it just on the pretext to evidence that they don't have it, that they bought it because they stamped it and they sold it and they sold it and they sold it. Now, if I leave my phone on this counter and somebody comes, picks it up and walks around with it, it's hard to consider that as theft. They could argue and say, we're holding on to it, blah, blah, blah. We were going to give it to you, blah, blah, blah. But if they sell it, that's theft.